The next case is Deutsche Bank versus Kawhana James. As you know, each side will have 15 minutes for oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you wish any rebuttal time, let me know how much, and I will give you a hand signal when you're approaching the rebuttal time so you can stop.
Good morning, Your Honor. Emily White, the Dan Law Firm, on behalf of appellant Kawhana James. We would like to reserve 5 minutes for rebuttal. The trial court erred in this case in granting summary judgment in this foreclosure case on the basis of affidavits and evidence that did not meet the criteria under Rule 56E and this court's well-established precedent for summary judgment. In a foreclosure case, the plaintiff, appellee, has the obligation to submit evidentiary quality materials that show that it's entitled to enforce the note, that it's entitled to enforce the mortgage, if it is not the original mortgagee, that it has a chain of assignments. It must also show that there's actually been a default in that obligation. It must show that it has complied with all conditions precedent in the case, and it also has to show the amount currently due. Now, this court has a long series of case law establishing what's necessary to be entitled to foreclosure on summary judgment. And the case law, Loya, Galaba, and Dvorak really drills down to Rule 56E's obligations for affidavits. This case, being decided on summary judgment, was decided on the basis of 2 affidavits, which quite frankly were deficient. They were not sufficient to establish the entitlement and possession continuously of the plaintiff to enforce the note. They were not sufficient to establish a default. They were not sufficient to establish the condition proceedings was complied with. I'd like to direct Your Honor's attention to the affidavit, the first affidavit submitted in this case, and sort of compare it with the affidavits that this court addressed in especially Dvorak, which happened to be the same trustee. In this case, we have a 3-page affidavit submitted by Daniel Leone, who is a second assistant vice president of Specialized Loan Servicing, LLC. This affidavit provides no detail about Mr. Leone's job duties, what his obligations are, or what his responsibilities are. And in fact, in the affidavit itself, he informs us that all of his personal knowledge is based on a review of the business records in the case. So he has the same information that we do as far as personal knowledge. He does also say that the loan records for the borrower are maintained by SLS in the course of its regularly conducted business activities, are made at or near the event, by or from information transmitted by a person with knowledge. So he does recite the evidence rule 8036 criteria for hearsay. The problem is he cites that for SLS, and the evidence and documents that he attaches are documents that have been prepared by entities other than SLS. If we turn to the second page of his affidavit, he informs us that SLS did not become the servicer on this loan until November 1st, 2012. And yet in paragraph 9, he tells us that a default had occurred 5 months previously, back in July 2012. So Mr. Leone, second assistant vice president of SLS, is telling us about, he's relying upon business records that were not produced by SLS. It's hearsay. Yes, it's hearsay. It does not meet the criteria under 8036. In addition, there is evidence that his affidavit is not based upon personal knowledge. This court in Dvorak, Loya, and Balaba has said that although in an ordinary case, one might take one at its word, that they have personal knowledge of the contents of an affidavit, where there is information that suggests that there is not personal knowledge, that assumption goes out the window.
What was his job title?
His job title was second assistant vice president. I'm not sure how that differs from a first assistant vice president or a vice president, but that is his title, and no further information is given about what his job duties are.
So his job duties are designated as having responsibility for the maintenance of the records and the accuracy of the records, or anything normally associated with the records custodian.
That's correct. In fact, he does not give any information about what his obligations are. Instead, he simply says, in my capacity as second assistant vice president, I have access to SLS records that are maintained in the ordinary course of regularly conducted business activities. So he says he has access to them. And he says, I make this affidavit based on my review of those records related to the borrower's loan. That is not sufficient to show personal knowledge. And I think that the issues with that become more clear as you move forward in the affidavit. This court has warned against, particularly in affidavits, statements in the alternative. The note is here or it's there. There are, those kinds of statements appear throughout this affidavit. For instance, paragraph 7, at the time of the filing of the complaint, and continuously since plaintiff or plaintiff's agent has been in possession of the original note. Well, which is it? Is it plaintiff or is it plaintiff's agent? Likewise,
What's the distinction?
well, the distinction suggests that he does not himself know where that note was, that he himself doesn't have personal knowledge. By stating something in the alternative, that is suggesting that the person is not certain about the fact.
Well, unless he's holding it in his hand when he's testifying, how does he know where it is?
Well, he would have to give us the basis of his personal knowledge. If it is in fact on a business record, he could say, based on my review of business records, and of course under Rule 56, he would have to attach that business record he relied upon and say, yes, because of this business record, this is what my knowledge
So
is.
there was no note attached to his affidavit?
There was a copy of a note attached to the affidavit, but the copy of the note does not tell us where that note was. Where that note was is a piece of knowledge that he says he gets that from the business records itself. If I look at a copy of the note, I can't tell where it has been.
He doesn't say it was in the possession of the bank's records custodian.
He does not. He says he has access to them. But even if he were the records custodian, as the court has said in Loya, somebody reading a document, that itself is hearsay. So if he simply said, if he is basing this on a review of a document, that's how he knew where that document was. He needs to attach a copy of that document to his affidavit under Rule 56E. Another example of this in the alternative is paragraph 12 of his affidavit. He says, attached hereto are true and accurate copies of the note with any applicable endorsements. He's not sure whether they're an endorsement. A mortgage and any applicable assignments of the mortgage. So by saying, that lack of precision suggests a lack of personal knowledge by Mr. Lamb. I would also point out that, like so many affidavits in summary judgment cases, this one is not even personalized to him. He's got a rubber stamp on his name. He's got a rubber stamp on his title. This affidavit could have been signed by anybody else. It happened to be signed by Mr. Lamb. But under this court's well-established precedents, under Loya, Balava, and Dvorak, there simply was not personal knowledge sufficient to really to authenticate or qualify any of these records. And this being summary judgment, this is practically all of the evidence that was submitted. I would also like to highlight too both the hearsay concerns, especially with the default. Mr. Leon does attach a number of exhibits that he says are payment records that he claims were incorporated into SLS's records. Now, some of these documents come from Bank of America, and if you look at the actual exhibits, I have to be honest, to me they're gibberish. They're just series of lines and charts. allegedly showing a payment history. But what is absolutely clear is they come from two different entities. There has been no incorporation of these records from Bank of America into SLS's records. They just started over and produced new ones. And this case, the plaintiff has an obligation, the appellee has an obligation to prove default with evidentiary quality materials. And simply attaching an unexplained printout that was produced and prepared by another entity is not sufficient. There was no allegation, there's no averment that Mr. Leone was familiar with the business record practices of Bank of America, whose records he is submitting. We do not know that those records were created at or near the time of the event or occurrence by a person with knowledge. And even his averment that these were incorporated into the records of SLS, they are manifestly not.
You can continue, but I'll continue the clock and discount and let you have less later.
Sure. I'd like to state as well, in this case also, there is no evidence that all the conditions preceding to foreclosure have been satisfied. In this case, we had a paragraph 22, which is the atypical features of a note or mortgage. In this one, there's a specific notice that had to be given before foreclosure could be filed. It had very specific criteria, one of which was the borrower was required to be notified that she had the right to defend herself in the event of foreclosure. Mr. Leone attaches a letter that he claims was sent. That letter is missing some language that the note and mortgage required to be sent to her. That is a condition precedent, and it was not satisfied in this case. Thank you.
Good morning, Your Honors. May it please the Court, Jason Whitaker on behalf of the appellee. Your Honors, the appellants have raised two issues in this case for review. Though they broadly categorized the first issue as a 56E issue and a viability of the affidavit, what they're really getting at in the brief and at the trial court level is, can the plaintiff establish that it had possession of the original promissory note when it filed this case and at all times thereafter? What wasn't present in the initial argument by the appellants was the fact that, though they mentioned that there were two affidavits, they never got into what that second affidavit is. And that's very important because the appellee believes that this case more falls in line with the case that this court decided after this instant matter had been briefed, which was the Bayview Loan Servicing versus Bay Blue Capital Partners case. Having argued that case before the court, before two-thirds of this panel, what's identical between this case and that case is, in both cases, there was an affidavit from an employee of the counsel for the appellee indicating that the original promissory note had been given to counsel prior to the initiation of the foreclosure case. In both cases, the affiant, the records custodian of the counsel for the appellee, testifies that the original note was delivered to counsel for the purposes of filing the litigation, that she intook the note, that she copied the note, and that she compared the original note in the cabinet at the law offices with the note attached to her affidavit. And in both cases, the note attached to her affidavit is identical to the copy of the note attached to the servicing employee's affidavit, the records custodian for the plaintiff, the appellee, and it's identical to the note that's attached to the foreclosure complaint as an exhibit. And so where the Big Blue case and this case differ from this court's line of cases is that not only does the summary judgment affiant have everything contained within the affidavit and attached to the affidavit, there's also a supporting affidavit from counsel that is essentially uncontradicted. In the briefs of the appellant, there's one line, I believe, that references the affidavit in the original brief that basically says that you can't trust it. And in the reply brief, there's one sentence that says that it's insufficient. But because it doesn't reference that the copy is a true and accurate copy of the original. When in fact the affiant says that she's the person who physically received the note, put put it in the cabinet, pulled it out of the cabinet, and copied it, and then compared that copy with the original. And so that fact is highly distinctive in relation to this court's prior decisions in Loya, Villalba, and Dvorak. It is unique to both the Big Blue case and the present case. The second issue that the appellants raise is this issue of the language that's contained within the notice of default and whether that language comports with the language in the mortgage. The mortgage, paragraph 22 of the mortgage, I think both parties would agree that that paragraph governs what is supposed to be contained within the notice of default. It references four things: that the notice has to specify the default, the action required to cure the default, a date not less than 30 days by which that default must be cured, and that failure to cure the default may result in acceleration. In examining the affidavit and the arguments by both sides, it's apparent from the briefs that the appellants are conceding the receipt of that notice, and instead are arguing that the notice is somehow insufficient to comply with the terms of the party's contract. But when you look at the notice, which is attached to the plaintiff's summary judgment affidavit as Exhibit E, the notice specifies the date for which the payments are due. It specifies the amount necessary to cure that date. It specifies that the borrowers, the defendants, the appellants, have 33 days to cure that default and gives them a date. And then it specifies in paragraph 3 that they have a right to reinstate the note after acceleration. And in paragraph 2, it says failure to pay those terms by the date provided may result in the acceleration of the entire balance, and with some language in between, and foreclosure of the property. And so the language that the appellants say should be there, which is to somehow separately put them on notice that they have a right to defend the action, is not contained within the notice. And practically speaking, we're all here today because the defendants appeared and contested and defended the foreclosure action. This was not a judgment by default, it was a judgment by summary judgment. So they not only had actual notice of the pendency of the action and concede the delivery of the notice of default, but they also can't point to a single piece of the language in paragraph 22 that requires something other than what's in the action, within the notice of default of theirs. We would submit that under this court's line of cases and under the Big Blue case, that the affidavit in support of summary judgment, which contains nearly identical language with relation to having access to a loan account, having viewed the records, having relied upon the records. And in this case, again, probably different than some of the other cases, the affiant also attaches a copy of what they would call the hello letter under RESPA, indicating that this is the date that specialized loan servicing is taking over the loan account from Bank of America. This is the current balance. This is the current status of the account. You have 30 days to dispute that debt. And then there's a further averment in the Leone affidavit that indicates that all of Bank of America's records have been adopted and merged into those of specialized loan servicing, and relied upon them in their ordinary course of business. And so, just because in compiling a payment history, the servicing agent does not completely recompile the Bank of America payment history on its own letterhead, does not mean when it looks at the payment history and its loan account that it does not include all of it, because it does. And I think the affidavit states as much. And in fact, I would imagine that some reviewing courts would have a problem with a servicing agent that takes a prior services payment history and just puts it on its own letterhead as if it's something that they created. And instead, what the plaintiff servicing agent is saying in this case is essentially, this is the state of the account when we got it. Here's the letter showing that we notified Ms. James and anyone else on the loan account that this is the balance due, this is the state of the account, you have a right to dispute the debt, and here's our payment history from that point forward. And we would submit and argue that the defendants do maintain some right or some obligation to have some reciprocal burden of proof here. So if they would like to argue that they have made payments on the loan account or that the payment history is incorrect in some way, that they have some obligation to show that, particularly when the entirety of the argument is just it's on a different letterhead, therefore it might not be true. We believe that there is no genuine issue of material fact, that the trial court correctly ruled in that manner. And the trial court did so both with knowledge that it has to construe all evidence most favorably to the non-moving party, but it certainly does so with knowledge of this court's precedent and the fact that a number of summary judgment decisions have been reversed to it. So we would ask the court to affirm the decision of the trial court and to recognize that this case falls in line with the Big Blue case and it is an exception to this court's line of cases in Kawhana, Villalba, and Bora. Thank you.
You have your 5 minutes.
Yes, I'd like to briefly address 3 points. First, with respect to the Billy affidavit, it simply did not state that it was a true and accurate copy that was attached. And it might be a harsh rule, but the 11th District, the Greentree versus Luce case, establishes that when you're at the summary judgment stage, you dot your I's and you cross your T's or it doesn't count. And the Billy affidavit was simply insufficient and not evidentiary quality material. Second, with respect to condition proceeding, counsel for Deutsche Bank did accurately read the first half of paragraph 22, but I would like to direct your attention to the pertinent part. After relaying 4 different parts of notice that must be given, paragraph 22 continues, the notice shall further inform borrower of the right to reinstate after acceleration and the right to assert in the foreclosure proceeding the non-existence of a default or other defense of borrower to acceleration and foreclosure. And yet, when you look at the letter that was sent out, it tells Ms. Parks that she had the right to initiate her own court action if she had any claims or defenses that she wanted to proceed to pursue. Those are very different. Those are very different things, and this is a very specific paragraph 22. It's a very specific notice that must be given, and it was not given in this case. And finally, I would like to address the point about default and whether that has been established. Counsel suggests that Ms. Parks had some sort of obligation to present evidence regarding payment. In fact, at the summary judgment stage, that thresher burden doesn't shift until the opposing party has submitted evidentiary quality admissible materials showing that it is entitled to foreclosure. What we needed here first from appellee was a submission of non-hearsay evidence of default and a 1-page grid printout filled with acronyms, numbers, and who knows what else that is submitted via an affidavit by a person who says his sole knowledge of that record comes from reviewing it. Just viewing business records, he had no other personal knowledge, is not enough. And although he did say that he has personal knowledge of his own employer's business and record-keeping practices, he says nothing about how that payment history was recorded, whether it was recorded at the time by a person with knowledge or anything else. We've got to take his word, and apparently Bank of America's word, for the accuracy of that default. That was plaintiff's burden in the first instance to prove, and I believe they have not met that criteria in this case. I would urge the court to reverse the decision granting summary judgment to the appellee and send this case back to the trial court for trial.
Thank you. Take the case under advisement and send it